We bring in tons and tons of information, which Guardian's going to ignore half of it. And then we have a whole world of information to argue to the court to say, Judge, they didn't consider these 10 things. They acted unreasonably. You have to reverse their denial and award benefits. And if you don't know what you're doing in these appeals, there's no way that you can write a strong appeal. I am Greg Dell, joined by attorney Alexander Palomara, and we're going to talk about Guardian long-term disability denial claims. And Alex, let's go briefly into the remedies if someone's been denied. We have a lot of information out there, a lot of videos on Guardian disability appeal, Guardian disability lawsuit. But for someone who might be sitting there and saying, yeah, look, I have this denial letter, what do I do? Why do they have to write an appeal? And why is it so important to do it right the first time?
So ERISA, the Employee Retirement Income Security Act, one of my clients, I can't take credit for it, came up with the acronym, the Employee Really Is Screwed Act, because the ERISA laws do a lot of things. One of the things they do is it says if they deny your claim, you cannot just go ahead and file a lawsuit, say, I want to take them to court right now, this is BS. You can't do that. The laws require that you file an administrative appeal. So you're going back to Guardian asking them, hey, you messed up. Take a look at my file again and overturn this decision. But you can't just say that. You have to give them arguments and evidence as to why and where they messed up. So when someone comes to me with a denial, I've reviewed the denial letter, I ask them what's going on, where did the insurance company get it wrong? What are your complaints? What are your symptoms? Look, and the denial letter will cite to it, some of the evidence that they're hanging their hat on to deny the claim. They might focus on an independent physician consultant's review or whatever it is, or independent medical examination. And once I sign this client up, the first thing I do is get a copy of the claim file. So I need to find all these reports that Guardian has relied upon to deny this claim. And the reason why I need to find these reports, because if my client really is disabled, these reports have holes in them. The doctor overlooked something, or the medical evidence was missing, this, that, and the other. So I have to find those holes, and I want to fill those holes with updated medical evidence and argument as to where the insurance company, where Guardian messed up. So it's imperative to get a copy of the denial letter, get a copy of the claim file, also to hire us to help you with this appeal. Now, why is the appeal so important? Another thing that ERISA does is that if the insurance company denies your appeal, your claim file closes. So let's just say, and when I say the claim file closes, that means no more piece of evidence can ever get inside that claim file. And the one thing that ERISA does for lawsuits is there's no testimony. You can't call your doctor to the witness stand and testify on your behalf. Right. You can't get on the witness stand and testify on your behalf. So the claim file is so important because that's all the evidence that the judge is going to see. And another thing why ERISA is terrible or makes it difficult for claimants is that there's no jury trials. It's only a federal judge rendering a decision on the claim, and all they get is that claim file. So your appeal there's two reasons to do a great appeal. One, gives you a chance of getting back on claim with the appeal, and two, it's your last chance to strengthen that claim file for your lawsuit. So you have to make sure by the time you file the appeal and before the insurance company, before Guardian issues that final denial, that everything that's possible that supports your claim is in that claim file, because the day they deny your appeal, the claim file is shut. And if there's more evidence that you wanted to get in, you'll never get it in. So the appeal is the most important thing you can possibly do on any claim, is to help you avoid a lawsuit or at least strengthen your lawsuit.
And I think that we do talk badly about ERISA in the sense that it's not fair, but that's our background in being trial attorneys, that we want to elicit the testimony out of our client. We want the judge to see our client. We want to take the deposition of the claim rep at Guardian that denied the claim. We want to speak to the in-house doctors that they hired who basically did a paltry review, really poor, minimal review, and ask them questions and, make it obvious that they were wrong in what they did. But you don't have the opportunity to do that. But the advantage is that we do know what the world is that lays ahead, meaning we know all of the evidence. There's going to be no surprises. And this is what we're going to argue. And with that, in the appeal, we get to put into the record whatever we want, which is great. So we bring in tons and tons of information, which Guardian's going to ignore half of it. And then we have a whole world of information to argue to the court to say, Judge, they didn't consider these 10 things. They acted unreasonably. You have to reverse their denial and award benefits. And if you don't know what you're doing in these appeals, there's no way that you can write a strong appeal. So we always tell people, send us your denial letter, provide you an immediate free consultation. We'll let you know immediately. We're not going to accept your case unless we think we can recover benefits. Why? Because we don't get paid unless we make a recovery. So our interests are 100% aligned. We're not just going to take a case, just take a case. We're not going to ask the claimant for any money. unless we think we're going to make a recovery. And the last thing that I'll just touch on briefly for us is the lawsuit. And if you lose your appeal, you have the opportunity to file a lawsuit. It can be filed anywhere in the country in federal court if your claim is governed by ERISA, which is the requirement. We have filed these all over the country. We choose the best court that we think is best for our client. And what people really need to know is that this process is not going to be painful for them. That's the advantage of this kind of thing. They're never going to get deposed. They're never going to have to go to court. The only thing they may have to do is appear for a mediation. And the idea of the mediation, which is what a lot of people want to know, is where's this thing going? Where's this lawsuit going? And where's it going? It's going to go, if we take your case and file a lawsuit, it's going to go to some kind of settlement offer. And you're going to have the opportunity at that point in time to say, here's X amount of dollars for your claim, buy you out, be done, a complete divorce. Or if you don't want this settlement offer, then we're going to let the judge decide. And what does the judge decide? The judge decides, should we pay the benefits that were denied to you or should we not? But what the judge's award is, if you win and the judge agrees with you, is only the back benefits that were not paid either up until the time in which you filed the lawsuit or up until the time in which the judge makes a decision. Now, if you had never been paid benefits before, most of the time the judge is going to remand the case back to the insurance company and say, I need you to evaluate this claim because I think up until the point in time that you denied benefits, you were wrong. Well, guess what, Alex? It's 2 years from when they denied benefits. Insurance company has no medical records for 2 years. Now they have to reevaluate the claim for a 2-year period, and they can deny the claim again. So you waited over 2 years to win your lawsuit, to then go back and get, a year's worth of benefits, to then possibly get denied again. It's a vicious cycle. And then appeal. And if you lose the appeal, lawsuit again. So not to say that if you're, disabled that you can't get a verdict, because you absolutely can. And one of the beautiful things about getting a verdict is you can get an award of attorney's fees, which will completely make a person whole and then some, potentially with additional money that's there to be as a credit for attorney's fees for you. But it is a vicious cycle and people love lump sum settlements. They don't love them, but the sense is they like the finality of them. And that's the beauty of getting a settlement. And what we do is we convey the offer. We give an opinion as to what we think are the chances of success. If we think you can win, we'll tell you. If we think you're going to lose, we'll tell you. But you're the captain of the ship, as we always say. So if you're someone out there who has a guardian disability claim, feel free to reach out to Alex, myself. No matter where you live in the country, we're available to assist you. And we look forward to the opportunity to provide you with a free consultation.